Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios East and West, we have a guest kind of somewhere north and in the middle a little bit, transmitting across the internet. This is episode 76, Larry. 76 of Registry Matters. How are you tonight?
Wow. We've been doing it this long and they haven't run us out of the territory yet?
No, I'm telling you, they haven't kicked us off. They haven't shut us down yet. None of that. We're good.
That is amazing. And we're growing rather than shrinking.
We are that. Yeah, our numbers are looking halfway decent, man. You know, I told you a certain number when we started, and we are a good chunk higher than that without any extra push from any other marketing channels or anything. I'm pleased.
Oh, well, let's make it a goal that we're going to double these numbers by January 1st of 2020.
Sounds good to me. Do you know what I did last night, Larry?
I have no idea.
You have no idea? A patron, a longtime patron supporter, he was driving sort of through my neck of the woods, and we had dinner last night, so we had, that was kind of cool. I don't know, other than at the conference, have I met anybody from the podcast. And so it was good. Mike was driving up to visit his sister in Alabama, and he drove through my way, and so we had dinner. That was good times.
All right. Well, that sounds fantastic. Was it one of our favorite patrons? Of course, they're all favorite.
It was. But, yes. So. All of them are favorite, but this is longtime supporter. I have him listed in my phone as super patron.
Oh, so this was super patron. All right. That's the one that gives us his gross pay, right?
Yes. He put in the big fat numbers.
All righty.
So we have a guest joining us tonight. We have Guy Hamilton Smith. And say hi, Guy.
Hello.
Thank you for joining us very much. You are can you tell me what a legal fellow is before I even go into this? Because I don't know the term.
Well, so basically, I work for the Sex Offense Litigation and Policy Resource Center at the Mitchell-Hamlin School of Law. And I'm working on a legal fellowship there, basically supporting the activities of the center. And also, supporting, legal and policy development in this sort of area of litigation policy more generally as well. So, it's essentially, legal fellowships can sort of run the gamut, and it really just sort of depends on where you are, where your fellowship is, and who it's being funded through, but. Because I'm attached to the center, so pretty much all of my activities relate to this. All my work is relating to this kind of area of the law, which is to say, the development and of effective sexual violence prevention policy that also respects fundamental civil and human rights, and so that's where a lot of our work is.
And then also, I put you down as a Twitter extraordinaire because you have a truckload of followers and you have a bajillion likes and tweets and all that. And you're also going to be a speaker at NARSOL's conference next month.
Yeah. Well, my wife says I tweet too much, and she's probably right. But
I've seen battles go back and forth. I mean, you guys have public conversations back and forth.
Yeah. No, she's on Twitter too, and she, yeah. And yeah, I'm really looking forward to the opportunity to come speak at NARSOL. I'm not really going to be talking too much about legal. I'll be talking a little bit about legal issues, but really mostly what I'll be talking about is I think the importance of people being willing to kind of be open and tell their story, and how that intertwines with good and effective advocacy when it comes to changing people's minds.
Gotcha. We did get a tribute from I'll call him a fan of yours, and it says, "This is Jeff from Kentucky. You know me as Captain Crazy on Twitter. I wanted to thank you once again because I believe you saved my life. Reading your story really helped me. I'm so happy you're on the Registry Matters podcast tonight. And of course, FYP." Do you know what FYP stands for?
I don't know what FYP stands for.
Larry, why don't you explain what FYP stands for?
Friendly young people.
No, that's not what it is. Stop that.
So we named our network as we build out. We're trying to have our own network like EIB, So we're FYP. And it came about
Yeah.
because Andy asked a question about what would happen. People think they have the right to know, and we never challenge when they say, "Don't I have a right to know?" And of course, I say, "Well, no, actually, you don't have a right to know who's living next to you." And I said, "Why don't you try going up to your door, going to your next door neighbor and knocking, say, I've got a clipboard here. I'd like to take a list of who's living here and see what." And Andy said, "Well, it's something about FYP, and that's where that comes from."
Well, it was
that's
supposed to generate somewhat of a laugh.
No, I'm just still. So what does it stand for? I'm sorry.
If someone came to your door and they knocked on it and said, "Hey, we'd like to know who lives here," what would your response be?
If you take out the P, what would you think those words stand for?
Oh, got it. Yeah, okay.
And take out the profanity, so we could say "frack you people."
Yeah,
that's
got
what it stands for.
Okay.
So it's like we never push back on that. When someone says, "I have a right to know," you say, "Where's that right enshrined? Where do you have a right to know who's living at a particular place? Where do you think you got that right?" But we always say, "Yes, I have a right to know," and I don't say that. I say, "Absolutely, you do not have a right to know."
Mm-hmm. It's such a powerful impulse too. That kind of drives a lot of these laws. That whole right to know and. Figuring out how to talk to people about it and how to get people to engage with it. It's difficult. It's tricky. But if certainly someone came to my front door and was like, we want to know about who's living here and we want to know about your family. My response probably wouldn't be very, delicate.
We would probably say FYP.
I would probably say something along those lines.
And that's one that bugs me. Another one bugs me is anytime an offender that's on the registry is interviewed, they always, when the interviewer says, "Well, aren't you ultimately responsible for your situation?" But when they're complaining about unconstitutional laws and all the infringements, and the person should say, "No, I'm not. I'm only responsible for my behavior, which I own. The unconstitutional laws are not mine. I didn't make them." I would ask you, don't you feel responsible for these unconstitutional laws? But they always say, "Well, yes, I guess I am." It's kind of like, yes, we have to have a right to know. When a person says, "I have a right to know who's living there," say, "Where's that right? Can you cite to it?" And they can't. Of course, you have no right to know who's living anywhere.
Mm-hmm.
Larry, why don't you introduce this late breaking segment that you're trying to introduce?
All righty. Well, we're going to have a new segment on the podcast if it takes off from tonight. And it's going to be late breaking news. And we've got some late breaking news that we're going to cover tonight. It's a decision from the 8th Circuit Court of Appeals, which is based in St. Louis. And we're going to talk about internet restrictions and an appeal decided by the 8th Circuit. And it just came out Friday, thanks to Hank, one of our loyal listeners. He passed it on to us. But the way we visualize the segment is that something that's newsworthy, and it's not just newsworthy, it's not defined because you like it. It's imagine that you're planning the program and news that someone else out there across the country, since we have a nationwide and even I think somebody outside the borders of the United States, at least one listening, what would people want to know about? This is an example right now of what people would like to know about. So we're going to talk about this fantastic decision. And of course, it's not the way we'd like it to have gone, but it's building a body of case law, which may ultimately bring this issue before the Supreme Court on restrictions on a supervised offender as a person on federal supervised release. And so I think we can leave it mostly at that. But this segment will be, please send us your suggestions, something that's breaking news worthy at the last day leading up to us recording on Saturday. And if you send it to us by what's the best method, Andy? Who's our regular email?
You could email it, you could tweet it, you could send it through Discord or voicemail. We could cover it all kinds of all the usual communications channels.
And we would talk about it on the next day. But if it's something that's been out there for a month and a half, that's not really news. But this is truly late breaking news. So hopefully we can have at least something that's late breaking in the day leading up to the podcast that we can talk about. So that's late breaking news. And stay tuned, and we're going to talk about it in the main segment of the podcast.
Very good, very good. I don't think there were any voicemail messages this week either. But we did excitingly get 2 new patrons, and we got an Alita, and we also got an Aaron. And I would definitely like to say that patrons make the Registry Matters podcast possible. That's a lot of P's. And thank you to the new patrons, and of course, thank you to all of the patrons. We also got a listener question coming off of Discord. I think it was on Discord. A person said, I have a question about federal probation. Do we have to take the polygraph test? Seems to me they make me sign a piece of paper that specifically states that I'm requesting to take it. What happens if I say no? I would ask my PO, but I think that wouldn't be smart. Any thoughts or suggestions? Why don't you two both tackle that one?
I'm gonna defer to Mr. Hamilton Smith first.
Well, I mean, what I would tell that person is that's definitely a question that you would want to talk to your attorney about. Anything that could potentially get you jammed up with your PO and get you into back before the court on a revocation proceeding. That's definitely a question for your attorney.
What would happen if you said FYP?
Well, there's only one way to find out that I don't necessarily advise. Doing.
Well,
so Larry, what would you suggest?
I would expand slightly on it, but I agree with Guy that if you have an attorney on your speed dial list, you should call them. But I can say I know of no case law whatsoever that says you do not have to take a polygraph in the federal system. And this is what the person's asking about. Now, there may be some states, I'm not aware of them, but there may be such where there may be some case law that says you don't have to take a polygraph. But the polygraph, the only case law that I'm aware of at the federal level is out of the 10th Circuit, and that's the United States versus Von Behring. And that case does not stand for the proposition you don't have to take the polygraph. What it does stand for is that you can invoke your Fifth Amendment rights not to incriminate yourself if the danger of prosecution is real and significant and not imaginary and fanciful, I think the way they put the words. But you must take the polygraph test unless you can cite to something that says you don't. And I don't know of any such authority that says you don't have to take the test. Is it right? No. Is it the way the world should be? No.
You couldn't say I refuse to take the whole thing, but you could refuse a specific question or something like that, right? If they ask you what your name is, you should answer it. But if they ask you, did you do this thing on this date, then you could refuse.
Well, and there again, we're giving legal advice if we go too far. But I could say based on Von Behring, if you read that as a layperson, they did not say that you can refuse the polygraph. They said you can refuse to incriminate yourself if the danger of prosecution is there. And so the danger of prosecution is not going to be there in all questions. So that would flow to a person like me. I would interpret that it means that you would have to answer questions that were not potentially incriminating that would send you away. And but I would agree with Guy. If you have an attorney, talk to them. But I can tell you, saying I'm not going to take a polygraph. I think we have an incident. Don't we have out of Georgia where a guy did that? That we know of, Andy, where he told his PO was going to take a polygraph. Do you remember that one?
Seems to like vaguely touch something, but I don't remember much more of the details.
And he got locked up right away.
Now I totally remember who that one was. Never mind. I remember speaking to a person on his behalf, and she was saying that, he doesn't have to take one. And he basically said FYP, and they immediately put him behind bars.
So it's not the world the way we would like it to be, but the case law's got to develop more. And as long as this voodoo science is accepted and the treatment community pushes it as being viable, and it's a necessary tool to keep the treatment honest and productive, as long as that mentality is there and they've got the lawmakers and the policymakers on board with that, it's a big business, and the polygraphers are not going to voluntarily come in and say, we don't want to do this anymore. We don't want to charge $300, $400, $500 to give these voodoo tests. Right. That's not going to happen. So they're going to be around until they're stopped.
I can't, right up there with residency restrictions, the number 2 thing on my list is the polygraphs, because it's just such garbage. God, it bothers me so bad.
Yeah, I do think that there is a sort of an increased awareness, though, that of sort of the compulsory nature of a lot of these, because, polygraphs tend to be used in conjunction with, treatment programs. And, of course, polygraphs are not really, therapeutic to begin with. Who goes to their therapist's office and then their therapist is like, well, before we, start working on your depression or your anxiety, I'm going to polygraph you because I believe that you're lying to me. So it's not, to begin with, it's not really therapeutic, but of course on the back end of that, comes with, if you don't take the polygraph, or, if you're not, to whatever the treatment providers, the treatment provider's satisfaction, you're not complying with the polygraph or complying with treatment, then you're of course at risk for getting revoked, and additional sanctions being levied on you. And there was a recent case, I think it was out of the Seventh Circuit Court of Appeals, that you all may have talked about last week, but where they did find that Indiana's treatment program, which I don't think they singled out polygraph specifically, but they did kind of illustrate this tension between the Fifth Amendment right against compulsory self-incrimination, and what treatment, quote unquote, looks like in a lot of these programs, and polygraphs kind of fit right in there. But as you said, it is also big business. There's a lot of money that's kind of tied up in it, which makes it, I think, if there's a lot of money tied up in it, and if it's not best practices, then it's of course even harder to kind of get people to come off of it, just due to financial incentives.
That was Lacey versus Butts, and we did talk about it.
Mm-hmm.
It's a fantastic decision that's hopefully. I'm anxious to litigate that issue in my state. These circuit court opinions, as you know, are not binding, but they certainly are a nice persuasive authority to put in when they have a well-written analysis. And so we're chomping at the bit to do that litigation in my state, because we were one of the pioneer states in terms of jamming all that polygraph. Actually, in our statutory scheme, as far as I know, we're the only state that will allow polygraphs to be admitted in the guilt or innocence phase of a trial. It's a very restricted admission, but we accept a polygraph under certain limited situation. I don't think any other state does, but we have it in our sex offender supervision statutes that the polygraph is an appropriate tool, and that they've been blessed by the lawmakers to use it.
Are we ready to dive into these articles?
We are.
All right. The first one comes from Reason, and this just goes up there with our criminal justice system is designed by assholes. The terminally ill, wheelchair-bound inmate applied for compassionate release. The Justice Department argued he wasn't dying fast enough to qualify. I guess if he were bleeding out, they would determine that he's only got 7 minutes to live, so they would open the gates. But if you've got maybe 10 years to live, that's not fast enough. The guy's already 55 years old or something.
The reason why I put this in here, and I'm the culprit for this one, I put this in here because it demonstrates the importance of who controls the executive branch. The Bureau of Prisons, this is a BOP. They have statutory authority to grant compassionate release. In many states, including mine, we have the same authority. But under the previous state administration, they never granted it. And this is what we're seeing from the attitude of this current administration. Now, I don't want anybody to say, well, they did this back in 1947 under Truman, because we're not under Trump. And Trump controls the Bureau of Prisons through the appointment of the Attorney General and through the appointment of the Director of the BOP, and how the senior management runs. But they have the authority. Congress has done all they can do, because this is a discretionary decision that can be made based on circumstances. And the executive branch is choosing to take a very hard line that we don't let anybody out. So who you put in control of your executive branch has a lot to do when there's discretionary decisions to be made, how the discretion is exercised.
Yeah, so the Reason article, is sort of construing, compassionate release under the First Step Act. And the thing that jumps out to me is that, prosecutors, you had, line prosecutors with the DOJ, opposing this, motion for compassionate release for this person who had this, brain tumor. And this just, what jumps out at me is, when you're a prosecutor, your job is supposed to be doing justice. And I think a lot of times, you have a lot of these cases where prosecutors are arguing things that are not, it's not really in the interest of justice to, keep this person, dying in prison. Just like, for example, prosecutors will all the time argue against having inmates with colorable innocence claims have DNA evidence tested to either confirm or deny their claims of innocence. It's like, why are you arguing? That doesn't really seem to be in the interest of justice. It just seems to be in the interest of ensuring that the state wins. And that's what jumped out to me here too, is just that. And I think that, at the end of the article, Kevin Ring's quote, just that, you have DOJ, the Department of Justice and the Bureau of Prisons, fighting, quote, tooth and nail to keep this guy in. It's like, is that really an appropriate or good use of, resources? And of course, I would argue it's not a good or appropriate use of resources, but but it also doesn't surprise me that this would be the that they would fight it.
Larry, from your experience, is it just about your team winning regardless of what the larger picture is? It's like, I've staked my claim to say that this guy is a monster and he needs to serve his time. No other circumstances matter. They're just going to hold on to you forever until the sentence is over. Are they just going to dig their heels in and hold it?
Well, as an oversimplification, I think that is the net result, yes. But I think it's an oversimplification. They have a lot of pressures on them when you start talking. Since we're the incarceration nation of the world, and we talked about that statistically, we're like 5 times the next closest country. Mm-hmm. You've got a lot of people in prison, and finality is important when you're running this vast machinery. So you've got a lot of considerations when a person is convicted. Then the tables shift in terms of the burden, whose the burden is on. The burden is you're no longer presumed innocent, whether you got convicted by a plea or whether you went to trial. The burden is now shifted to you, and the vast machinery is not staffed to continuously litigate those cases. So I don't think they'd spend a lot of time determining whether they believe you're innocent or not. I think they spend more time on trying to keep what they would see as the proverbial floodgates from opening. And the victim's advocates, the person who got justice finally, would be, can you imagine the outcry if the prosecutor said, oh, well, yeah, I guess there is a little bit of doubt there. We'd like to see this case reopened. And can you imagine the outcry that would ensue about how they've jumped to the offender's side. Now, they actually do have a higher ethical duty as an attorney. A prosecutor has a guy, I think you can attest to this, that a prosecutor has an additional rule of professional conduct to seek justice. But I don't think they conspire per se, or they stay awake at night just to be winning. I think it's the pressures of everything that goes into that. It's like, my plate is already full. The cops have pumped all these cases to our office. If we don't take these cases forward, then we get blasted by the cops and by the victims. And I think the whole system is just it's misplaced priorities. I don't quite see it as simplistic as our team has to win, but that is the result.
Right. And then moving into an article from WSBT up in Michigan. It's about another registry being created to fight for child abuse registry bills, where a woman, she was dating a guy and then her kid ends up with the shaken baby syndrome. So she dates a guy that had other issues of some sort of like child abuse stuff. So now this mom is running around trying to get, she is saying that she's going to fight until she's no longer able to fight to create a registry that lists child abuse just in general. But at the very end of the article, an individual says that maintaining registries like the one proposed by Wyatt's Law can be very expensive. And the person said studies show that they do not keep the public more safe. Yet here we go with another registry, and then there's another one in Florida. We're going to talk about it in a minute too. Silly, man.
Yeah, I think that a lot of the times you have these bad, these difficult cases, and then a registry will get proposed as the solution, as the fix. And, it's kind of, they're always difficult to oppose kind of rhetorically, right? Because they're named after these really difficult cases, Wyatt's Law or Megan's Law or Jessica's Law. And so that kind of disarms critics. But, if the goal is to prevent, in this case, physical abuse, physical child abuse, then, all available evidence is going to indicate this is not going to, I mean, much like sex offense registries and other public conviction registries, this is, not going to do really anything to address the problem. And it will be expensive. There's going to be a huge, sex offense registries have turned into this kind of huge outlay, or have required a huge outlay of expenditure, both in terms of money and public safety resources that could be better invested elsewhere if we want to prevent sexual violence. So ditto here. It's if we want to prevent child abuse, which I think is I think we should all agree that's a really good goal. So then we should look at how we're going to do that in ways that aren't going to be, both ineffective and also inhumane. Registries are kind of the emblematic, I think, legislative proposal for things that are ineffective and inhumane. But it's also like catnip for legislators too, because they don't have to engage in any serious study or policy making about an issue, and they can just sort of propose this legislation that would more than likely just go through, and then when their reelection comes up, they can say, I care about our kids, and look at this legislation that I passed. So it's really, from a political perspective, it's kind of like a win-win. It's just not actually going to do much to address the problems that we want them to address.
Larry?
Well, I don't have a lot to add. I would say that I'm not as confident that this is going to pass. I think, in particular in Michigan, with all the battle they've had with their registry, their sexual offender registry, there's going to be some hesitancy with the Attorney General's office taking the position that they took, that the registry went too far, and admitted that. I think that this registry, it's easy for a lawmaker to introduce a bill. I work in an office where I see the process, and it's really easy to have something drafted up, but passing it may be a little bit more difficult. And of course, if it gets out of committee, like I tell people, if something gets to the floor, it's very difficult to vote. No, you darn sure don't want this on your re-election opponents. When you have a re-election opponent just on their radar that you voted against establishing a registry to protect child abusers for a kid that was beat up as bad as this one was and went through what he's gone through.
Right.
But I would not share the belief that this is just going to magically sail through. It would have 5 years ago. 3 years ago, but I think there's going to be at least some serious discussion in committee, and it may not make it out of committee.
Let me just throw this out there to both of you. Do you, if you were to put your pulse or take the temperature of the nation on the idea of the registry, do you think that, is it changing? Is it getting cooler, so to speak? Is there some level of skepticism from the public at large in the effectiveness of these things?
In my experience, I think things are changing. I don't think that this bill necessarily is gonna pass, because I think, with everything going on in Michigan, the Doe versus Snyder case and the ACLU trying to kind of hash out an agreement with the legislature. But more generally across the nation, I think that the public is more skeptical of registries and as kind of like public safety. But it's also kind of, I wonder, we have a lot of catching up to do, because, even as the public is kind of getting more awareness about what these things are and how they're not really very effective tools, registries have also proliferated, both in terms of just the number of people who are on sex offense registries, but then just the number of other types of public conviction registries that states have adopted, that are, sort of continuing to spread, like the one in Florida that I guess we're going to talk about later. So I do think that things are changing, but I think that, which I think is a really positive and hopeful sign, that there is at least space for conversation about, if we really care about problems like child abuse or human trafficking or sexual violence, that we can approach this discussion in ways that are kind of grounded in sort of reason and evidence, and not just kind of go with what go with like what sounds good, and what everyone else is doing. So but again, I think we have still a long way to go.
The way you put that is funny. Larry, what do you think?
I don't know how to think anymore, Andy.
Well, let me tell you what to think. Just kidding. How about we talk about some people in Alabama that when they get transferred to this one particular prison, that they get. I reading the article, I was like, oh, I get why they're doing this. This article comes from truthout.org. And inmates in Alabama are shackled to buckets for days on end. And if you're carrying contraband and they shackle you to a bucket, you can't relieve yourself in any place other than the bucket. And you're not going to be able to hold on to any contraband for more than... I can't imagine you would make it past the first cycle. But anyway, so now you have to like live and sleep near your bucket of poo for days on end, which I find to be over the top. Like we talk about the Eighth Amendment and cruel and unusual punishment stuff. This qualifies.
I don't see a problem with this, Andy.
I know you're being tongue-in-cheek. Let's just be clear, right?
So, yeah, let me tell you, we've got to make being incarcerated in this country tough. That way people won't be... the prisons are like a darn country club. They get better medical care. They have cable TV. They live in air-conditioned luxury. People out there are working to pay the taxes, and Alabama's got this right. They need to make prison a place where they won't want to come back. And by golly, you'll see the rate of crime plummeting in this country if we do that. We mollycoddle these criminals, and that's got to stop. Do I sound like a good conservative there?
I think you are right on the money with the thought process about this one. Like, feed them bread and water, chain gangs, 16-hour work days. So what do you think about that, Guy?
Well, obviously, I think we have a real problem when it comes to punishment in this country. And it's not just that we incarcerate, a higher percentage of our population and that we do it for, longer, but also the conditions of confinement that we put people in are... Because, of course, you hear that argument all the time from people that we need to make prisons, inhospitable so that people won't commit crimes. It's like, but that, I think that doesn't really understand that when you take someone away from their community, you take someone away from their family, like that in and of itself is punishment. And in, many other first world democracies, like that's sufficient. You don't need to make the conditions of confinement, such that the person is going to be, sort of suffering from PTSD or exposed to violence or, be forced to eat, basically be forced to eat food that's going to adversely impact their health. And I think it really what a lot of it tracks back to is just that we have a real problem with punishment. And we have a real problem when we sort of consider people who are criminals, that we can treat them in ways that we really wouldn't treat our animals. We wouldn't treat our pets this way.
But these people have committed a crime against the citizenry, against humanity, and they deserve to have the shit thrown at them for hours, days, months, years on end until they repent, they say they're sorry, until their whole life is destroyed and they can't come back. I don't know. I struggle with this one so bad.
Most people have committed a crime,
Agreed.
That's the reality of it. It's just, these are the people who got caught. And that doesn't necessarily make them that doesn't necessarily make them good people or bad people. But they need to be held accountable, of course, for crimes that they commit and harm that they cause. But I don't think chaining them to, forcing them to defecate into a bucket for, days on end really accomplishes that, or does anything for anyone that they harmed. It really, I think it all goes back to, what do we want to do? What do we want our policies to do? Do we want to create safer communities? Do we want people, when they come out of prison, do we want them to live law-abiding and productive and meaningful lives? And if we want those things, then it seems we could adopt policies that would encourage and incentivize those things. But we don't. I'm not entirely sure that's really sort of what we want. I don't think we really care that much about safety. I think there's other considerations that sort of loom larger in our cultural consciousness. And I think that's very much reflected in, incidents like, these kind of horrific prison scenes that are that bubble up to the surface, particularly out of Alabama lately. There have been several stories about Alabama prisons that have kind of been, well, I would say hard to believe, but of course,
right.
This is very, very easy to America.
What do you think about the difference in the incarceration mentality, nationwide, like, taking pockets, whether that be the South versus the North or East and West, red versus blue? Do you have a sense of which ones either are more effective or are filling the gaps?
I'm not, I'm not sure about sort of I know that there are regional differences, of course, but I'm just not as well versed in that to be able to really, speak to it, intelligently. But I will say that it isn't like I think everywhere is not, is pretty punitive. I don't think that you're going to have much of a difference in between like Maine and Vermont, where interestingly they don't ever take your right to vote away in Maine and Vermont. So you can even vote while you're in prison serving a sentence, which I think is a good thing, by the way. But prison is still prison. It's not sort of transformed into something else. I think you have much bigger differences if you look outside the United States, particularly like Germany or Norway. But in the United States, we still have we have a very punitive mindset. And of course, some states and some regions are, I think, more punitive than others. But generally speaking, we're fairly punitive.
Well, I would say that having presented about there are vastly different rates of incarceration in this nation. It's astronomical, the difference, and even the lowest state, of course, in this nation is higher than the civilized nations we like to compare ourselves to. But you'll find a far lower rate of incarceration in New England than you will in the southern states of Georgia, Alabama, Mississippi, and that deep South. And it's not only just the rate of incarceration. It's the way like you wouldn't find a chain gang. Alabama brought back chain gangs in 1995, according to this article, and they had chain gangs had largely disappeared by the late 1960s because we had evolved into a more enlightened era of how we dealt with offenders. You won't find a chain gang in Vermont or New Hampshire, but you're liable to find them all over Mississippi, Alabama, Louisiana, although they might not chain the inmates together, but they still put them out on these horrendous work details with very minimal accommodations for the elements that they're working in and very, very rudimentary equipment. And they work them very long hours. And so there's a vast difference. Now, prison is still prison. If you're in prison in Maine, you're not going to have the freedom, but you might get more visitation time. You might get more educational opportunity. There are significant differences in how we operate prisons in regions of the country. The South, like Alabama, if you look at their inmate per expending, you'll find it's very low in the South because they have too many inmates, for one thing, and the mentality is we don't want to spend all of our money on prisons. We've got other important priorities, so they do everything they can to minimize what they spend, and you have inadequate health care, inadequate everything in Alabama Department of Corrections.
There's an article coming from filtermag.org. Florida approves database to publish details of people who pay for sex. I just got to think that right off the bat that a good number of people on this list would be people that would have the power and money and resources to not be presented on a list. It is, I guess, semi-often reported that, famous people, politicians, etc., have paid for sex. So, the number of people on that list are going to be the people that are creating the list that voted on it. You'd think that they would have voted it down right off the bat.
Well, Florida is, when it comes to registries, Florida is sort of in a class of its own. And from what I understand, I mean, Lauren, was this legislation, was it sponsored by Lauren Book?
Drafted by her.
Was it drafted by her? Yeah, I mean, and that's sort of the thing, is that the people who have money and resources and connections, they can sort of avoid the most draconian consequences of, pretty much any law, right? And so these, it's sort of like, ramping up mandatory minimum sentences. That's really gonna have the heaviest impact on, defendants who don't have resources or who can't work out a plea deal to avoid a mandatory minimum, that sort of thing. But of course, I'm sure there are plenty of people in the Florida legislature who voted this thing into law who would, probably otherwise be on this registry. And it's just really unfortunate that it's just going to be going through. It looks like it's going to be going to the governor's desk. And I know that there are people who are, still engaged in advocacy and organizing in Florida to try to, do something with this law. But it's really I think it's really unfortunate, because it's just like, I wish that senators like Lauren Book would take their sort of considerable profile and resources, and if they're really concerned about, sex trafficking, which I think was the ostensible rationale, like underneath this legislation, to address it in ways that are effective and not just slap another registry on it, which like Wyatt's law in Michigan isn't going to address the problem. It's just going to sort of create new problems.
Certainly. Larry, what do you think?
Well, I'm not sure if this is going to the governor. I wasn't able to it looks like that the House bill is passed and the Senate bill is passed, but I'm not sure that an identical bill is passed both chambers. But that'll be for the Floridians to tell us if it is actually going to the governor. But some of these things end up being gender equity. And what I mean by that is that you have a hard time when you're trying to figure out a strategy to deal with prostitution. There are those who believe vehemently that you should go concentrate on the provider of the service, and there are those who believe vehemently that you should concentrate your resources on the purchaser of the service. And the purchasers of the service are largely men. Women, very few women pay for sex. I mean, there are some, but the overwhelming pay for sex is hired by men, whether they're hired men or whether they're hired women. But women just have a way of needing to engage in that tactic to get sex, and so the pressure is on to decide where you. I happen to believe that demand is the source of the problem. And without demand, you won't have sex workers. If there's nobody out there trying to purchase sex, you'd stand on the street, or you'd run your Craigslist ad at a time, and you wouldn't have any business. So demand, but this is apparently one of those things where they're trying to make a statement that you people who create demand for this and cause humans to be trafficked, you need to pay, and you need to pay with shaming. And that's what I see is going on here. And this is going to hit mostly on males. But if you're a male in the Florida Assembly, you can't vote no on this, because then you've got 50% of the population mad at you because you don't care about the people who are being exploited sexually. And there's a lot of exploitation in the sex worker industry. It's not a glamorous life to live.
I mean, I think that it's kind of like, well, I mean, we've tried this kind of this approach, this sort of philosophy of trying to address, like, social harms like sex trafficking, or if we want to characterize it as sex work, or whatever it is. Like, we've had this war on drugs, for example, for the last several decades.
Years.
yeah, and we've kind of had that same philosophy. Is like, well, we need to target, we need to criminalize it and punish people, and but I don't think we've really won the war. It doesn't seem like we've won the war on drugs. It seems
no,
like
not even close.
there's still people that have, that have addiction issues, and there's still drugs, and the same is going to be true with, with sex work. And I wish that we could adopt a more public health oriented approach. To use the drug example, Portugal, I believe decriminalized all drugs and have just essentially treated drug addiction as a public health problem. And they've had really, fairly decent results, although drug policy is not my area of expertise. But
hey, and on that note, Colorado decriminalized magic mushrooms yesterday.
I did hear that.
Yeah.
And I don't know any of the details.
Yeah. Moving on to an article from Arizona Mirror, azmirror.com. Sex registry bill defeated as senators protest failure to expand rights for sex abuse victims. This one, Larry, can you cover this one in some level of detail?
I wish we had an Arizona person, but I can do my best. There's an effort to do more for the victims of sexual abuse, and to do more for victims, you have to jettison the rights of accused, and you have to expand the statute of limitations. There are so many things that victims advocates want, and there was a bill that would have expanded the statute of limitations. Arizona apparently has a very narrow window, and that bill was defeated. So this bill that would have provided relief was also killed in the process because it was retaliation. If you're not going to do anything for the victims, by golly, we're going to kill your junk bill also. So that's what I took away from it. The Senate Bill 1255 would give childhood sexual abuse victims 7 years after they turn 18 to sue, and that bill died.
So where do we go from here then? And that just makes the whole thing dead. I assume that then they'll try to reconnoiter the thing for the following year, or at least the next session, whatever.
Well, I would not be in a position to say I would assume that, but it was such a horrible. The removal bill was deeply flawed to begin with. It's kind of like the California removal from registration bill. They technically have a process now, but it's so flawed that very few, if any, will ever get off. And this bill, from what the Arizona people told me, was far from being broad enough to provide much relief. But for the narrowness that it passed through the process, and it was almost ready for a final vote, apparently that it didn't satisfy the needs to help people be removed from the registry. But I don't know what they're going to do, Andy.
It just seems it seems strange to me that the removal bill. So there were two bills, one to broaden the statute of limitations, and the other two that would allow for some people who are on the registry to be able to petition for removal. And the removal bill was killed when the statute of limitations bill was also killed, as Larry was saying, in retaliation. The rationale was, if you're not going to help victims, then why should we help, people who are on the registry? But that kind of misapprehends the whole, rationale and purpose of the registry. If the registry is supposed to be about public safety and about, ensuring that, people don't, cause additional harm. But if you have to the extent that the registry is a useful public safety tool, which I don't think that it is. But just for the sake of argument, if you have a bunch of people who are on the registry who aren't a threat, and then you have legislation that can remove them, doesn't that also help? That also helps victims. At least in my mind. So
I can give an example from like an IT point of view that I have a bunch of systems that watch other systems, and I get notifications. And in the case of like a massive outage and my alarms just start going off, and they repeat and they repeat and they repeat, I stopped caring about all the alarms because it's just like, obviously that's not important anymore because, anyway, it just continues, and then I end up becoming numb to the whole thing and I don't care anymore. If there's one person on the registry, well, but that person is the danger. But if you have, 80,000 people that they do in Florida, 20,000 of them are dead, who are you looking out for?
And I should stress, even when people, even if people do have high needs, there are ways and sort of models of ensuring that, their reintegration into the community is successful, that and that are evidence based, and don't rely on sort of shaming and stigmatizing them to death. But that's just an aside. But it just seems to me the framing of this article and this dispute between these two pieces of legislation, Arizona. Really, to me, it's all about helping ensure that, it's really both helping to ensure that victims, essentially about preventing sexual harms. And I think there's certainly a lot that I could talk about, why I think expansion of statute of limitations is, in many respects, problematic. And this is the point. I think they're well intentioned, but I think that there's other ways to go about it without necessarily undermining either constitutional protections or, I guess this is civil litigation in Arizona, but without sort of enlarging the power of the state.
Well, I can do a little bit better job setting it up because I see a key paragraph in the article that I had overlooked. The House bill that would have made the registry removal process slightly expanded the removal process or created. I thought Arizona already had some limited removal process, but anyway, that was House Bill 2613, and it only expands eligibility to be removed from the sex offender registry for certain crimes, and it has several stringent requirements. Offenders must be 35 years old and must have been clean for 10 years, and their victims cannot have been over 15 years of age. And so it was like I say, very, very limited. But when it got to the Senate side, it fell on an 18-11 vote because of the sex abuse, childhood sexual abuse bill, Senate Bill 1255. The committee chair would not give it a hearing, and so since the committee chairman Eddie Farnsworth declined to give it a hearing, this was a retaliatory strike. The members have power. The committee chairs have a lot of power, but the members also have power. And they said, well, we can't make you have a hearing, but we sure can kill something you like. And they did.
This doesn't seem like any of the, Guy, you keep bringing up evidence-based, and so much of there's nothing in the way our laws are drafted that says that they must be evidence-based. They're just complete emotional,
right. There's no requirement that legislatures enact good policy, and or that it be evidence based, which is of course unfortunate. And a lot of this, when we're talking about registries, a lot of the problems with these policies not really being evidence based can kind of be laid at the feet of the Supreme Court. Way back in 2003. But yeah, if we really, if we were really concerned about having a good and effective policy, I think that we would be a lot more responsive to data. We would be a lot more responsive to evidence. But these areas they're so, there's a lot of pain, and there's a lot of anger, and there's a lot of fear. And those emotions, I think, while really understandable, also don't make, they don't make it easy to really deal in, evidence when you're talking about these issues. So, of course, we have just a whole tangle of policies that are not, they're not really evidence based, but are extremely politically difficult to get rid of.
I'm glad to hear you. Glad to hear you say that, Guy, because people say that things ought to be evidence-based, but I get to make my favorite. Well, that's not the way it is. And beyond that, you said that bad public policy can be made. And just because something is bad public policy, that does not in and of itself render it unconstitutional.
Yeah, right. Yeah.
We have the right to enact bad public policy.
Yeah.
The robes are not there to protect you from things that you do by electing people who will enact bad public policy. That's the gift of democracy, of representative government. If people are enacting policies that you don't agree with, the reaction you should have is to remove them from office. But you don't go whining and crying to the judges to say, save me from myself. We made a boo-boo. You can only be saved from yourself when you've convinced the judges that they did something that violates the Constitution, not because they did something that wasn't evidence-based. It can be bad, but that doesn't render it unconstitutional.
But I will say though that there are, I think courts also can't just, in this area of law, courts tend to want to punt, which I'm sure you all have also seen a lot of. And what I mean by that is, when they're confronted with sort of the evidence that these policies, like not only are these policies ineffective at their stated goals, but they're, arguably harmful. Courts will say, well, that's really, we're not going to get into any of that stuff.
But that's not their role. That's not their role to save you from bad policy.
Well, but there is a check on that. That the court does still have, the judiciary does still have they have an obligation to review factual findings where constitutional rights are implicated.
Correct. But just because you don't like a policy, we can make the 50-mile-an-hour speed limit, break it to be the law of the land again. That's
Sure.
a bad public policy, but it's not unconstitutional.
Sure. I mean, it's not unconstitutional. I mean, you have to identify a legal argument that's beyond just this is bad policy. But getting courts to engage with sort of the evidence and the facts is also a sort of constant struggle.
Well, but again, the courts are not there to decide what's the best policy. That's not their role in our society. If you're willing to have prisons that are so now you could have cruel and unusual punishment taken on, but if you're just determined not to educate prisoners because you don't want to spend the money, that's not the court's role to come in and say you must provide educational opportunity because it would be a better public policy, because we'd have a better society, because these people would be better individuals. That's not their role to do that.
And then there were crickets.
Yeah, no, I totally get that. My point is just saying that the court can't, when constitutional rights are at stake, the court can't abdicate its role as in terms of reviewing factual findings.
I agree with their constitutional rights, but just because something is not a good policy doesn't implicate a constitutional right. And
Sure.
Our people struggle with that. A lot of stuff that we do in public policy is not good public policy. It's not good public policy that we waste 18, 19, 20% of our GDP on healthcare and have an inefficient delivery system that leaves a whole lot of people uncovered. But that's our right to do that. And the courts can't come in and say, well, I want to design a better healthcare system that'll consume less GDP and it'll provide more equitable distribution of the resources. That's not their role.
Mm-hmm.
That's what we elect people to do, to determine how to distribute the resources and what the best way to go is. And if we don't like
Sure.
that, it's our job to make that change. But the courts are not saviors from our own bad decisions, unless the Constitution has been infringed on. And it's our job to show by the clearest of proof that has happened. And otherwise, the presumption of constitutionality rules.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast.
we want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed.
We're going to move on over
possible.
to an article out of the Washington Post. Larry, we talk about people doing pro se litigation and how bad of an idea it is, but this guy did it, and he had been in prison almost 14 years. And he fought his case, and he's now a free person doing completely, and he went to court in his Department of Corrections outfit. He had whatever armbands he's supposed to have. It looks like he's got tats all up and down his arm. He's, forgive me for the way that this is being put, but he looks like a thug, and he went into the courtroom looking that way to identify himself this way, not to try and put on like the suit and be all prim and proper, but to show the people that he was being held, didn't deserve to be there, and that this was like cruel and unusual punishment, I guess, maybe you could say. And after, 81 minutes, the jury deliberated, and they let him go.
So I can say I don't advise that course of action, but it certainly worked.
I mean, if you're sitting there for that many years and, like, you could just spend all of your time reading the law books and stuff, and if you are truly innocent, I really hate the idea that anybody is behind bars that shouldn't be. And I do believe that I'm on the side of the equation that says that we should let more guilty people get off instead of locking up one person erroneously. I'm pretty sure I believe in that actual statement. And so here's a guy that was going to serve a lot of time and fought back.
Well, congratulations.
Guy, what do you think about somebody representing themselves?
I don't know what to say because it's usually a horrible practice. But
yeah, no, I totally
once
understand.
In a while, the blind squirrel finds a nut once in a while during the course of a day. So,
I mean, I think a lot of, I've met some very talented pro se litigants. In my sort of time in the legal field, I guess you'd say. Prior to taking this job, I worked for a criminal defense law firm where we did state and federal criminal defense, trial and appeals. And I met a lot of pro se litigants who actually had, seemed to be doing pretty well. There's also someone in so I'm also a Just Leadership Fellow for a 2019 Just Leadership Fellow, and in my cohort, there's a gentleman that I met who essentially got his own case overturned on a habeas corpus petition, and he did it all himself. So yeah, I mean, I think that there are certainly some very talented pro se lawyers out there, jailhouse lawyers, and there's a lot of bad ones too that tend to be more. But just because someone is representing themselves doesn't necessarily mean that they're, what's the old saying? Not qualified or, not intelligent, or the old saying is, the lawyer who represents himself has a fool for a client.
Right.
So representing yourself, it's, I don't think it's generally advisable, and I think it's generally court staff and judges, they tend to regard it skeptically because they see a lot of it that doesn't go, very well. But there are some very talented, very smart, pro se litigators out there too.
Oh, I agree with that completely, Guy. I've met some very smart. So the problem is you don't have the access to you're not treated the same way, regardless of your skills. As a non-admitted person, you don't have the access to go to the judge's chambers very easily. You don't have the access to run down to the prosecutor's office and say, "What do you think about my case? What do you have on me? How would you feel if I filed a motion to get me off probation?" It's a system that doesn't lend itself to a pro se person. Particularly if you're incarcerated, you can be a very gifted writer, but you don't have the access to move about and to communicate. But yes, I don't question that there are some very good, skilled litigators. I've seen some very nice writings come to me on a regular basis from people behind the walls, but the system's just not designed for you to be successful. It's stacked against you. Right. This is one of those cases where it worked, but the system is not very friendly to it. Imagine you're trying to get off the sex offender registry. in a state that allows a petition process. Well, the first step is down to the prosecutor's office to see how the office is going to respond to the petition, because generally that's where you have to serve them. So you go in and say, well, how do you feel about me, Mr. Prosecutor? Well, they don't even want to talk to you. They want to say, well, where's your attorney? Well, if they do talk to you, well, you were a real dickhead because you did so-and-so. Well, no, I didn't do that. You just can't engage in the conversation with the prosecutor about, well, I've actually got help. Oh, you did? How have you recovered? You see how that conversation goes? It's the same thing if you take yourself to a jury trial. When you're doing cross, you're going to say, now, you saw the defendant do, well, you are the defendant, so you saw me do that, right? It puts you in a very awkward position, when you're representing yourself. But I didn't mean to say that the people are not qualified. Some of them are. I'd say the majority of them are not. But the system doesn't welcome them into the process.
Larry, did you just say dickhead?
I did.
You said Richard Cranium on a family-oriented show?
Well, I think Dick is the name, so Dickhead. Somebody named Dickhead. You see where I'm coming from.
Yes.
About the system. Yes. Okay. But no, it's not to diminish obviously he had some significant skills to navigate that and accomplish what he did. So did Clarence Gideon.
That name sounds familiar.
That's a Gideon versus Wainwright from, what was it, 1963 or somewhere, about the right to an attorney.
Okay. All
Gideon, right. Yeah. So yeah, he was it Arizona or Florida? He was from a very conservative state. I always get it confused, but he took his case to U.S. Supreme Court on a handwritten cert petition.
I want to say Florida.
Maybe it was Florida. I'll look it up real quick. But yeah, and he certainly had persistence and stayed with it and established some great case law that's being weakened today, little by little, chipped away at. But yes, from a pro se litigant, we have Gideon versus Wainwright.
Although for every Gideon, you're going to have a couple hundred a couple hundred not Gideons.
Absolutely, yeah.
Larry, this next article I think we should have done as the late breaking news, because this one someone just submitted this one.
Turn on the news sounder.
Yeah, okay. Oh yeah. Hang on.
We can't do it without that.
This comes from Logan, Utah, and there is a 62-year-old man. He's a bus driver, and he was getting off the bus, and he was struck down by a bunch of teenagers who were called by one of the person's younger sister that said the bus driver had assaulted them. So then the brother gets all of his gang buddies together, and I shouldn't say gang, but 17-year-old teenagers, and they go beat the bus driver literally to death. They go play back the closed captioning TV system on the bus, and the bus driver walked by the female student, the one that alleged the inappropriate behavior, and there was nothing there. So the guy is now dead because of a false allegation. That's the news.
Well, yeah, I hadn't heard about that.
I can't fathom how we got here. So maybe the bus driver dissed her one day and cussed her out for not being on time or something. So here's the retaliation, and because of that, He's dead.
Yeah, I mean, just looking at the article now.
Yeah, I just put it in there a little while ago. I apologize for not being there sooner.
No, that's yeah. I mean, that's really. I mean, that's obviously tragic. And I mean, there are. I don't know really what would obviously possess anyone to, make an allegation like that. And then it's of course just tragic how this turned out. I mean, it looks like he, at least according to the article, that he suffered injuries when he hit the sidewalk.
Yes.
Which that happens so. I mean, that can happen so easily. I mean, in a fight.
I agree with you.
You just hit your head the wrong way.
He's also a 62-year-old guy. I mean, Larry, you remember 100 years ago what it was like to be 62.
God, that's going to go way back to think when I was.
I know, right? Can you remember that far?
It's hard.
Yeah, I just and it's not like you get paid a truckload of money. So I'm going to assume or suggest that the guy is probably not, he's not making a bunch of money. He's not sitting on a $10 million pension fund, and he's just doing this out of the goodness of his heart to transport some kids around to make sure they get to school safely. So that's where we have come, is that the people that are listed as sexual predators or anything like that, they are so vehemently hated that the immediate knee-jerk reaction is some sort of retaliatory response. And then in this case, it's a false allegation.
And what are they going to do about it? Do we have any information yet?
Well, that was going to be my next question.
Yeah.
What do you do with the 16-year-old girl who made the allegation and the 17-year-old brother and then all of his little buddies that came out and killed the guy?
Oh, well, in this state, you would treat them under attend to them under the juvenile system, which would result in whatever punishment they have would end when they turn 21. But I don't know what Arizona's going to do. They're quite a bit.
Isn't that Utah? Or did the case? It's out of Utah.
Oh, it's Utah. Excuse me. Well, I know most every state around us is more harsh than we are. So whether it's Utah or Arizona, they're far stricter.
Yeah, I mean, I think, of course, when you have, there's saying bad facts make bad law, and whenever you have a case that has bad facts, and people want to clamor to treat them, to treat these people harshly, and I think there's a growing sort of movement and recognition that sort of harsh treatment doesn't really produce good outcomes for anyone, even the victim, or in this case, the victim's family. So I think that there are, sort of wider and more encouraging movements within sort of criminal justice and how we approach violent crime, which this is obviously a violent crime, and how to fold that into a restorative justice framework where people who cause that harm are held accountable and are able to, sort of make amends for their crime. I think, the Redemption Project on CNN is, sort of bringing restorative justice for violent crime into the mainstream among, several other different outlets. So, in cases like this, especially, where you have a bunch of young people who made a really bad decision and something terrible happened because of that decision. I mean, they killed someone. I think that, situations like these can potentially be ripe for, as opposed to just saying, well, we need to, try them as adults and give them the death penalty. I don't think that that's necessarily going to produce outcomes that anyone is really going to be, is really going to help anybody. So, but of course, I don't know what they do in Utah.
I guess we can then go on to this final article. Larry, you get the job and the privilege of setting this whole thing up.
I do?
Absolutely, because you move into this whole legal propeller head stuff, and my eyes roll in the back of my head. I start drooling, and I have no idea what's going on. So, have at it.
All right. So where's my teletype?
Oh, you want that again?
Oh yeah.
All right, I'll give you the teletype.
So we have hot breaking news from the 8th Circuit Court of Appeals.
All right, there you go.
So now we have the breaking story from the United States Court of Appeals for the 8th Circuit. A case comes forth to us that we're going to talk about tonight, dealing with what are reasonable and unreasonable conditions to impose in a period of supervised release. And supervised release, for those who don't know the terminology, is a term used in the federal system. When a person is sentenced, they are given usually a prison sentence, but sometimes a probated sentence followed by if it's probated sentence, there wouldn't be any supervised release. But if they go to prison, which 90% of the federal offenders do, then you're going to come out on a period of supervised release called that's what they refer to the period. Well, during that period of supervised release, which can be relatively short, all the way to lifetime, there are conditions imposed, and this deals with a number of special conditions that were imposed on an offender who was convicted of a sexual offense related to possession of and attempted distribution of child pornography. And the conditions of probation restricted him from having access to internet, to devices I don't need to understand, but he has significant restrictions, which he challenged because he did not want those restrictions on him for the remainder of his life. and this decision from the Eighth Circuit Court of Appeals says that the conditions that he challenged, asserting that the Packingham case from the U.S. Supreme Court covered him, are not applicable because he's not in the same posture Packingham was in. Packingham owed society no debt. This person is serving his debt, although it goes for the remainder of his life. So the case, as it's titled, comes to us as United States of America versus Kevin Carson. And I think that I'd like to engage a little discussion with Guy here about these conditions, because he objected to either 2 or 3, particularly of the conditions. And I'd like to go through special conditions number 16, restricting social media access, and then there was special condition 14, which bans any possession of depictions or of nudity or any that merely alludes to sexual activity. Did I miss there's a special condition 6 that he opposed, that he was in opposition to. What was special condition 6, Guy?
Let's see. It looks special condition 6. Let's see. He challenged special condition 6 to the extent that it prohibited possessing or having under his control any matter that is pornographic / erotic. Was that condition that he was challenging?
And
sorry,
14, go ahead. And special condition 14.
Yeah, special condition 14, which prohibited him from possessing or using any computer or electronic device without prior or with access to any online computer service without prior approval of the probation office, and then also a condition that was essentially the law that was struck down in Packingham, but prohibiting him from maintaining or creating a user account on any social networking site that allows access to persons under the age of 18 or allows for the exchange of sexually explicit material, chat conversations, or instant messaging. So really a pretty broad ban on a wide variety of websites.
And he was shot down on all 3, correct?
Yeah, I mean, he was he appealed from the district court, and his attorney did not object to any of these conditions at his sentencing. And the significance of that is when the attorney doesn't object, then that makes it much more sort of difficult to overturn them on appeal. So the court basically said that the Eighth Circuit basically said that, we're going to affirm. We're not going to reverse on these conditions because, and they discuss at length the Packingham decision, North Carolina versus Packingham, which is 2017 United States Supreme Court decision that basically said that for people who are not serving a criminal sentence, the government can't say you can't use any kind of social media because social media is, they referred to it in Packingham as the modern public square. But in this case, he's challenging the condition that will be applied when he is ultimately released from prison, and he'll be serving a criminal sentence. He'll be on supervised release, which is kind of a federal, there isn't really federal parole, but it's kind of like probation or parole. You have an officer and you have conditions that you have to abide by. But the importance of that in this context is because the Eighth Circuit basically said, well, it's not really like Packingham, because in Packingham, he wasn't serving a criminal sentence. Whereas in here, you're serving a criminal sentence, so therefore Packingham doesn't apply. So the Eighth Circuit is basically saying that if you're going to be serving a sentence, then the government can in fact say that you can't use any kind of social media. The importance of social media to modern life notwithstanding is kind of my understanding.
I tend to agree with you. This is something that we've struggled since Packingham, because people who are getting these exceedingly long periods of supervision, and we've got listeners who are subject to for state convictions, community supervision for life, or in my case, a mandatory period of 5 to life. There's no end to this. So it's like you never can do those things that are essential to modern life. And the Supreme Court did tiptoe around with a little bit of runaway dicta that they found those conditions troubling, which were the issues of the restriction of North Carolina statute that kept anyone from being able on a registry to access the internet. But they said, we find these conditions troubling, particularly for those who've paid their debt to society. That may not be a direct quote, or who have served the totality of their sentences. Well, that suggests if they're particularly concerned about them, for those who've paid their debt to society, that they are also generally concerned, or somewhat concerned, or at least mildly interested in the people who are still paying their debt to society. So there was a lot of optimism, but I did not see that as broadly, because I've watched the courts become more restrained in their behavior because they've been hearing society lecture them for the last 3-4 decades about runaway activism from the judiciary. We need courts who interpret the law and not try to make the law, and that's not a vehicle to achieve your goals that you can't through the legislative process. So I've seen courts become much more tolerant, and things that used to shock the conscience of the court no longer shock the conscience of the court. So I was a little bit less optimistic that this was going to have the effect that people wanted, which was to extend to people under supervision. Having said that, I don't believe that means that there's no bona fide claim there. I believe that in a modern society, the essential usage of the internet is such that I believe that the Supreme Court would, based on that dicta, entertain this and help us realize that there are limitations where you can even not go with a person. It's kind of like prison censorship. Prisons have broad authority to censor materials coming in, but they don't have unlimited authority. Prisoners do have some rights.
Yeah, I mean, I think that social media and First Amendment freedoms in particular, if we're considering that in the context of someone who is going to be on, supervision for the entirety of their lifespan, I think that there is a possibility that courts could, look at that and give it a little bit of a different analysis than just saying, like the Eighth Circuit did, well, you're on supervision, so, Packingham doesn't really apply. Because, I think social media has become so ubiquitous, and it only seems to be becoming more and more ubiquitous. It's a little bit like saying, well, we're going to ban you from using the telephone. Like you can't use the telephone, because of course you might use the telephone to call a victim. And well, yeah, I mean, you could, of course you could drive a car to go find a victim, but that doesn't mean that you can ban someone from using a car. So yeah, I think that as we have more and more people who are on these sort of lifetime parole, lifetime, supervision arrangements, it could be that we're going to see opinions start to, I guess, question their constitutionality. But certainly not this opinion, though.
Well, there was a dissent. A guy, and that's usually a good thing. If you're filing a cert petition, you're going to hammer on that dissent, and you're going to say,
"Oh, sure.
Well, this is a split opinion here," so there is a pretty well written dissent.
Absolutely.
How do we get the internet to apply like just like air? You can't say someone can't have air, but you could restrict them from a particular place. How do we get? I mean, I'm a huge fan of the internet. I'm on it all the time, and it freaks me out when I go by a Burger King and it says apply at bkjobs.com or something like that. And then I think of how many of our people are just outright restricted from, how are they supposed to get a job if they would require to use a computer and the internet to then apply for any of the jobs? And we've just said, nope, FYP, you can't use a computer.
Well, that's sort of exactly the way I mean, this has been an issue that's been very, that I've been very interested in for many years. And, my perspective on it is this. I mean, it's that these tools are essential for reintegration. And if we want people to reintegrate into society and to live healthy and productive and law-abiding lives, then they should have access to them, because, I mean, they're becoming essential for modern life. And if someone, if you can say, well, we're going to ban these people from these platforms, but if someone wants to commit a crime,
right?
I mean, they're gonna commit a crime. They're not gonna, they're not gonna say, well, I can't use the internet, so I guess I can't get on the internet and commit a crime.
You have wonderful cats, guy, or a cat.
Yeah, yeah. Sorry about that. Yeah, no, I locked one out of the office, and she's
unhappy about it.
She's unhappy about it.
I didn't mean to mess up your train of thought.
No, it's totally fine. But it just essentially, I mean, that, yeah, these are essential tools for reintegration. And if we want people to succeed, right? I mean, we want them to succeed. We want them to live productive lives, because if you're someone who if you have a home, if you have a family, if you have a job, if you're going to school, like, these are all reasons to stay out of prison. And that should be what we want. But to the extent that we continue to isolate people, I don't think that really works for the benefit of the goals that we that we want, or that we should want. But that's my 2 cents, and I'm sure my cat agrees with me.
The possibility exists that he can have limited controlled access to, at least to the internet. But I think the condition said with his approval of the probation office, but then that's a lot of hurdles to jump through. And then the condition on the social media, it seems like that's blanket. But even social media, although I'm not a big user of it, it's becoming more and more essential for particularly if you have an independent business. Social media is how you connect with customers nowadays.
Yes.
So it's becoming a fact and a necessity of modern life. So I think that this body of case law, although the circuit courts appear to have come down consistently the same way the 8th Circuit has, those who have ruled, like the 5th and the 11th and the DC Circuit have had similar decisions, and they've come down the same way as the 8th did. But I would not give up. I mean, somebody should file a cert petition. But I'm thinking maybe if you look at the facts of this guy, he may not be the ideal candidate to file that cert petition, because he's a very unsympathetic individual when you look at what constituted the facts of his offense, and that's going to weigh heavily.
Sure, yeah. I mean, it's also not a it also procedurally, because this attorney didn't object. It makes it a heavier lift. So yeah, I mean, and there are certainly some defendants who are more or less sympathetic than others. But I mean, it also, it also seems worth pointing out that, I mean, he is, child pornography defendants in the federal system are the most heavily punished defendants out of any class of offender in the federal system. Like, he received a 20-year sentence and then lifetime supervision, and then even on that 20-year sentence, the bottom end of his advisory guideline range was 30 years.
He got a downward departure. He got less than what he should have gotten. Oh, well, not what he should have gotten, but guidelines recommended.
But I mean, it's just a 30-year. The bottom end of the guideline range being 30 years is, astonishing. You very outside of child pornography offenses, you very rarely see recommended guideline ranges like that.
Well, just for those who want to read the opinion, we're going to link. We'll have that in the show notes, and it's only 13 pages. But the officers seized, and we've highlighted some of the relevant. The officers seized Carson's electronics and hard drive, on which they discovered 593 still images, 99 videos, mostly depicting child bondage and bestiality, including a horrifying image of a female infant being raped by an adult male.
Wow.
That is going to be somewhat. It's going to discombobulate an average human being to want to dig into this issue because of the visceral reaction you're going to hear to child bondage, bestiality, and an infant being raped. It's just going to be hard for a human being, which all these judges are going to be mortal humans. They're going to have a hard time dealing with that.
I understand why you said not a very sympathetic plaintiff, I guess.
Yeah, and there again, it's not the world the way it should be.
A person in chat just said I threw up in my mouth a little bit.
Well, I mean, sure, like he didn't produce that. At least my understanding of the case is that he didn't produce that image. I mean, that was an image that he had on his computer, which I mean, obviously, yes. Yeah, and that's that's a terrible, that's a terrible image. But I think there are a lot of these prosecutions, and I think in this case, he also, the defendant also engaged in. I think he was engaged in some sort of a sexual relationship with a 16-year-old, and was also sending pictures to other
You're correct.
Other teenage girls. So I mean, there's more than just child pornography possession here. It's still, it's still a remarkable sentence. I mean, you don't really see sentences like that, even for abuse cases or homicide offenses or other types of cases. A lot of it comes down to ick factor, and also the way that the federal sentencing guidelines will really hammer federal defendants who get in trouble for possessing or distributing child pornography.
Well, on that note, Larry, is there anything else that we have to hammer out?
Well, we're going to just remind people that if you want to submit some late breaking news to do, it has to be of interest to more than just a small group of people, but something that would be appealing knowledge that others would like to know throughout the land. Send it to us, and we will hopefully continue this segment of late breaking news.
Good. Guy, I can't thank you enough for spending an hour and a half with us, and you've been very generous, and I can't thank you enough and appreciate you coming on.
Yeah, no, thank you all so much for having me. I hope it was I hope it was an enlivening discussion for your listeners.
Absolutely. And so Larry and I are going to close out the show, and we'll let you go on your way. Unless you want to hang out and talk to some of the people in chat after we're done too.
Yeah, I don't mind hanging out for at least a few minutes and chatting.
Larry, I'm just going to knock these out really quick. What was that?
Let's do it. How do we make this podcast grow?
Well, we have people like Guy Hamilton Smith on, and he's going to tweet it to his 4,000 people, and then we will have 4,000 listeners. That's one. But hey, visit the website at registrymatters.co. If you want to call in for a voicemail message, it's 747-227-4477. That's a bunch of 7s, 4s, 2s, and 7s. I guess I said that twice. Email is registrymatterscast@gmail.com. The best way, we love you forever, all of our patrons, patreon.com/registrymatters. And I think that's it. So with that, Larry, Guy, thank you very much. And I hope you guys have a great Saturday night.
Good night.
Thank you. You too.
Appreciate it. Bye-bye.
Thank you for listening to the FYP Network.